Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Brittney Saint-Fleur brings us a trademark assignment agreement with an international twist. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen, joined today by my friend Brittney Saint-Fleur. Brittney, how are you today?
I am great, Mike. Thank you for having me.
I'm ready to be confused, Brittney, I gotta be honest, because I recently had a conversation with a buddy, Steve Sedberry, who talked to us about trademark license agreements. We're talking about something related, and you're gonna tell me the difference. This is a trademark assignment agreement. I'm pulling this from Law Insider. It is as between Shanghai Magma Digital, which I assume is also a cool club or something, and Hooray Times Communication, which I assume is a less cool club because it has kids there. Brittney, what are you seeing in this document? When are we going to run into this kind of thing? What is a trademark assignment agreement?
Okay, so let's start there. So with the trademark assignment agreement, it is essentially a complete transfer of ownership rights from one party to the next party. And that's the difference between the assignment agreement versus the licensing agreement, because with the licensing agreement, it's going to be for a period of time in which the owner permits the other individual to use their trademark, but not own it.
Cool. Okay. Well, that makes sense. So we're going to go through, again, you have you're dealing with a lot of international clients. These are two companies that are outside the United States, but they're in the same country. And so some of these things may not transfer exactly. And I hope you'll call out where things might be different based on where the countries are represented by these companies. But let's start with number 2, registration fees. It says the registration for the change of the registered owner of the trademarks shall be undertaken by the assignor, and the assignor shall bear the registration fees incurred hereby. What do you think? Normal? Who's normally paying these fees?
Well, typically it depends on what the parties agree on. I would say that I like the fact that this is a part of the agreement just because, you want to have all of these things kind of lined out before you make the decision to move forward, right? You want to make sure you know who's responsible for what and what you can expect from each party. And so the fact that they have the registration fees a part of the agreement is ideal. And the registration fees aren't too costly. And so it's not like it's a big hoopla for either party to take on either way. But, it's just nice to have this type of thing lined out in advance in the agreement.
In our conversation with Steve, he talked about, he analogized these kinds of situations to buying a house and representing title and having title insurance, all these things. I'm going to jump down to section 3 to representations and warranties, because you see in here these two companies making these kinds of title promises. So if I jump to 3.1.5, the assignor will not engage in any action that will be detrimental to the validity of the trademarks after the completion of the assignment. Of course, the stuff before it says, I own this, nobody else is after it. But then they're making a continual promise to not break it. 3.2, they've got, for the assignee, they've got similar responsibilities. If I look at 3.2.2, it says the assignee, subject to its business scope and corporate power, has taken necessary steps and obtained full authority and all consents to go and execute and perform on this agreement. So you're seeing between these two, not just sort of backwards looking, I own this, similar to a title to a house, but also some forward looking representations. What are you seeing in this section?
Well, it's interesting you compared it to a title of a home, because ultimately you want to ensure that when you're doing these assignments that the trademark itself has perfect title, right? Because what you don't want is for someone who doesn't actually have ownership rights to essentially be assigning it to someone else, because then it's invalid automatically, right? And so you don't want those issues, because at that point, fees would have already been paid, expectations would not have been met, and then everyone is kind of confused, and now they're having to take it to trial for infringement. And you don't want any of those issues. So the fact that this agreement requires perfect title before the transfer, and then also it also requires good faith effort from both parties to ensure that the assignment is seamless, essentially.
I'm looking just as a curiosity. You mentioned with assignment, you're passing it on entirely. It's interesting to me that they're representing future responsibilities as they talk about this when there is a full transfer. But also, just as an aside, I'm looking at 4 and effective date and term. It says this agreement has been duly executed by the authorized representatives as of the date shall be effective simultaneously. It doesn't have anything about term, about how this thing might end. I'm assuming when you're looking at these kinds of documents, it might not say, hey, this is valid for 10 years like a license does, because as you pointed out, you're legit handing the whole thing over.
For sure.
But is there normally like ways to get out of the deal similar to those kinds of license agreement? Do you have termination options in these contracts?
Well, typically, if you wanted to ensure those type of warranties, you would include them in the agreement themselves. And if you were to go down to 5, clause 5, it shows you that this is how they would settle the dispute if there's one that arises, right? And so because of that, that it's not just simply going to be someone feels like they got the short end of the stick, but they have just a course of action that they can take to ensure that they're not, being taken advantage of essentially in this agreement. And so it lines out exactly what steps that they should take in order to ensure that, again, they don't get the short end of the stick.
Yeah, the settlement of disputes is interesting. We've talked about this with arbitration agreements that sometimes companies will include this bit. It points out that they will strive to settle any dispute from the interpretation or performance through friendly consultation within 30 days after one party asks for consultation. And then if that all falls apart, we'll go to a binding arbitration. Is this normal that you're seeing this kind of with an assignment? Because this is not a long-term relationship in the same way that a license is,
right,
where you guys are sort of renegotiating every decade this deal. This is a full handoff. Is it normal to still try to preserve that relationship by saying, hey, we'll be buddies with each other. I'm not just taking you to court right away?
Well, ultimately, we can't truly say what's normal and what's not normal because, yet again, it depends on what the parties agree on. But the fact that this is in here, I feel that it's very beneficial for the parties, and it probably gives them a bit of relief, right, in moving forward with this agreement, just knowing that they have they have options if in the event that things do go awry. And this is always best. And I would recommend these type of options for dispute settlements in these type of agreements just because of that. Because what you never want is, again, if something happens with the trademark, because trademarks, they are valid, the registrations themselves are valid. Well, speaking for the USPTO side of things, they're valid for a number of years at a time, and then you have to renew them every so often. And because of that, you want to ensure that when transfers are being had, that depending on the time frame in which these transfers are being had, that things with the registration itself are intact. And the only way to ensure that if in the event things are not intact with the registration, that the individual on the other end of this agreement, that they have guarantees for themselves and for their business and for their brand, because these are investments people are making on themselves, on their families, and on their brands. So it has to make sense for everyone involved.
Yeah, and you mentioned to me in preparation for this conversation that you have background dealing with deals that go across borders, right? In this case, they don't go across borders. They're both within China, and they say under applicable law in 6, the interpretation, implementation of this agreement shall be governed by the laws of the People's Republic of China.
Yes.
This makes sense because they're both there. Tell me about when you're dealing with those cross-border agreements, how are the parties making decisions on applicable law? Are there defaults to certain countries? Do you see each side saying, no, the normal conflict of laws stuff that I'm going to pick mine versus yours? What are you normally seeing in these kinds of agreements?
Well, typically it depends on who has the advantage, right? Because you would think that the individual that owns the trademark, the assignor, has the advantage, but if for financial reasons they need to sell this registration and they need to transfer it over, then the assignee would have the upper hand in that situation, right? And so again, it just depends on the parties and what makes sense for the individuals that are a part of the agreement, the assignor and the assignee. and their brands, right? And for the reason in which
Right.
they're doing this transfer or assignment.
Right. Yeah, I want to ask sort of a kind of a broad question that helps me to think about these types of agreements. Usually with something like a license, or you've got these sort of long-term deals, and you have a responsibility if you're a licensee to go and exercise, get value out of the license, or you might lose it, right? You've got to go get
Right.
value out of the marks. When you're dealing with an assignment like this and there's a full transfer, is there a long-term relationship? Should there be? What is, again, we talked about the termination. There doesn't seem to be much in the way of, if you do X with this mark, I get to go take it back and kill this deal. What is the long-term relationship, if any, that you would see in these kinds of assignments? Would you like to have one? Would you like to have more enforcement on the back end, if that makes sense?
I think that the extent of the relationship that should take place is just with regard to renewals. And as this agreement lines out, the assignor cannot do anything detrimental to the registration or the brand itself um, prior to the transfer, right? And so those are the things that ensure that if there is ever something that comes up with the registration in itself, with the renewals, or if there is anything to basically disparage the mark itself prior to transfer or even after transfer, then you know that these are things that can be spoken about and settled between the parties, right? Otherwise, if you just have it where it's we sign the agreement and we move on, and you don't continue that relationship or that rapport to some degree, um, then you kind of leave yourself in a space where anything can happen. And I don't think that that's the best place to leave yourself in.
Right. Yeah, it's a little hard to do. What was the word that they used? Friendly consultation. A little
Yeah.
hard to do friendly consultation if you go take their trademark and then, beat it up in public. All right, well, cool. I appreciate you sharing this,
Yes.
Brittney. This is interesting stuff. Again, put in the context of the other ways we've talked about using marks. It's interesting to hear about this full transfer, and especially the international context. For people who want to learn more about that context, about dealing internationally in these kinds of IP issues, what's the best way to reach out to you, Brittney? Perfect. Well, we'll include that information as well as a link to this document over at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email me. I'm at community@lawinsider.com. We would love to have you. Brittney, thank you again, and we'll see you all next time.
It's been a pleasure. Thank you.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.